Mechoulam, some key takeaways, please?
Sure. I want to emphasize that when you look at these issues, it's important to remember that many federal agencies and state agencies enforce whistleblower laws, and you must be attentive to the regulatory regime in which you're operating so that you can address risk effectively. And to that point, I encourage everyone to be proactive. Don't wait for a whistleblower complaint to come in to start thinking about what should we do, how should we respond. You can take steps well before any whistleblower complaints come in to put yourself in as low a risk environment as you can be by having policies in place, developing really a whistleblower complaint response plan in terms of who are the people who should be handling it, what's the protocol, what are the rules of the road for anonymous whistleblowers. For example, don't try to identify them. There are, basic components to an effective policy, and even if something goes wrong in terms of how that policy is implemented, the fact that you have a policy and you try to implement it and you're consistently applying it can help minimize any exposure with respect to these kinds of complaints. So with that, I will turn it back to you, Sal.
And thank you, Deborah Mechoulam. Julie Jordan, any key takeaways that you have for our audience?
Sure. I think employers should be mindful of, as we see the increasing trend of more and more whistleblowers, that it's more and more likely that those whistleblowers will include, their own attorneys and their own compliance officers, particularly given their positions, they might be in the best position to be aware of potential violations of the law. And employees should be mindful of that. We've now seen at least 2 compliance personnel receive monetary awards under the SEC program. We've not yet with respect to attorneys, although I think it would be difficult for an attorney to get an award under the program. And in the case of attorneys, they really face complex issues for which there is no bright line rule either for them or for their employer in terms of what they're allowed to disclose in terms of privileged information. And the attorneys, face serious consequences for a breach of their ethical obligations. Attorneys' rules vary state to state, which mean there can be differing results depending on what jurisdiction you are in. While some states provide for an exception and a use of privileged material to establish a claim on behalf of an attorney with his client, others are more restrictive, in particular New York and D.C., where I'm located. That being said, employers should be mindful. The case law makes it absolutely clear, no matter what jurisdiction you are, that the duty of an attorney to maintain the confidential information is not an absolute rule, and the courts will engage in a very fact-specific inquiry and apply a balancing test to determine whether the attorney properly took that information and disclosed it. I will note that in the context of attorneys and sometimes even compliance professionals, there actually might be an additional hurdle that we haven't talked about today in order for them to sort of prove their retaliation claims, because oftentimes the whistleblower statutes require that the whistleblower have a reasonable belief of a violation of the law that they reported. And presumably a lawyer and a compliance personnel with expertise in a particular area should be more knowledgeable and be held to that standard in the context of a follow-on litigation. And then finally, I just want to leave you with one important note, and that was highlighted in Bio-Rad case as well as the other cases we talked about today. And that's sort of the implications of reporting of privileged information to government agencies in the follow-on employment litigation. In Bio-Rad, the court found the plaintiff was able to use privileged material under an applicable SEC rule, but they also found independently that given the company had offensively used the results of that privileged investigation against the employer and the government agencies, that they had also waived the privilege with respect to those materials. And I think that highlights for employers to be careful when they make personnel decisions. Oftentimes they're being made following an investigation. And one thing that we find attorneys do to avoid waiver and potential discovery of that privileged material in the follow-on employment litigation is to do a separate, HR track where you're setting up, giving the HR personnel the non-privileged information that you discovered in the course of your investigation and giving them enough information based on non-privileged materials to enable the HR group to make that termination decision.